some holding a case. Honorable Judge Emma Bliss is in the courtroom. We got State versus Holder tonight. Get going here. Howdy, howdy, everyone. Department of Justice, the Honorable Emma Bliss speaking.
Oh, perfect. Just the person I was looking for. Hey, this is Joseph Young with Robert Holder here.
Yes, Mr. Young.
We were trying to get our everything together. Is there any way we can meet in chambers prior to this session starting? There's something that came up we would like to bring to your attention. If the prosecution is around, then I would allow it.
I believe the prosecutor is out in the lot in the courtroom.
Okay, perfect. I don't have their information, but would it be possible that we could meet in chambers prior?
Yes. Give me a moment, and I'll have the bailiffs come and fetch y'all.
All right, sounds good. Thank you.
Thank you.
Where are they at?
Not. Have you seen any of our bailiffs?
No, I have not.
All right.
I asked where they're at.
I don't know. Let me find out.
No, I mean Mr. Young and all them.
I believe they're out there. I know Bradley's out there, but they needed to have speak with me before the case happened. So if you want to go out and fetch them.
Sorry.
Oh, had to stand up. All right. How can I help you?
Sorry, can you hear me?
Yeah.
Loud mic or nothing. Okay. We have found that the original police report has been removed. We cannot see that anymore. Along with not having the arrest report for Mr. Holder himself.
Hold on. Let me take a look here. Okay, the arrest report that's gonna be on me. I can get that fixed. We were doing some. I had to do some cleaning on my my drive when we moved offices here because the space was having issues. So let me get that corrected for you. Technical difficulties. Gotta love it. I accidentally deleted the arrest report when I was doing some stuff with my. Oh.
Yes, we can. Thank you. I appreciate that. Yep. And as it stands, just for us. On the charges that he's currently being charged with, is 2 counts of assault on a government employee, 1 count of resisting, and 1 count of felony evading.
Perfect. Wait, what? Okay. I missed it. Yeah. Go. I'm not, Your Honor, respectfully, it's too late for me to make arguments. So, I mean, I can argue till I'm blue in the face. Defense is just going to argue back. So, I think we're both ready for trial at this point. I disagree with that, but again, I can discuss that with you at a different date and time. Because how we were charging the defendant was very clear. But that's okay.
Nothing from the defense, Your Honor.
No?
Oh, yeah. There's one guy out in the courtroom being a little froggy, and he's going to find himself into a whole heap of trouble if he continues on. I wish we had bailiffs here, to be honest with you. Yeah, I have not either. Do you know if they have access to the lawyer's channel? Yeah.
You have reached an automated voice messaging system. 4 8
JS
0
department.
2 4 7.
Oh, you got it. There you go. All right.
You have reached an
Mariana Rice. How are you, Bliss? I am. I wish I could, but I'm with family right now. All right, you too. Have a good one.
Sorry. Thank you for reminding me. I'm
We have a team.
trying to track down some stuff. Thank you, Lame Boy, for the follow. Welcome to the Terror Squad family. Well, we ain't got no bailiffs. All right, that's fine.
All rise. Honorable Emma Bliss now presiding.
All right, you may be seated. All right, I, the Honorable Emma Bliss, now call case number CR 1058, State versus Holder to order. Prosecution and defense are both present. And I have Mr. Holder present. All right, well, I'll start with opening statements. Prosecution, the floor is yours.
Good evening, Your Honor. Is this working? Just confirming.
Yes, it is.
Perfect. All right, this case arises from.
Up, sir. Speak up.
You can't hear me?
No, just a little bit louder. More into the mic, please.
Okay, I mean, I can't control the mic, unfortunately. Okay, this case arises from a coordinated series of ATM robberies and related criminal activity carried out across Blaine County and the state. The evidence will show that multiple individuals acted together, utilizing the same vehicle and same vehicles, committed repeated offenses, and fleeing from law enforcement during multiple pursuits. During those pursuits, law enforcement vehicles were intentionally struck, and the suspects continued to evade with full awareness that they were being pursued. The court has already heard and seen evidence tying this conduct together, including officer observations, vehicle identification, and forensic evidence such as fingerprints recovered from the involved vehicles. Additionally, Your Honor, 2 individuals involved in the same course of conduct have already accepted responsibility and entered guilty pleas to the same charges. This further confirms of the coordinated nature of the criminal activity before the court. Importantly, Your Honor, the defense has acknowledged, based on their own review of the body-worn camera footage, that the defendant, Robert Holder, was inside the vehicle and exited from the passenger side. Accordingly, the defense's presence in the vehicle during these events is not in dispute. The state will show that the defendant was not merely present, he was an active participant. He remained in the vehicle during these offenses and pursuits and did not separate himself from the conduct, and ultimately fled from law enforcement. Under LPO 4, a person knowingly participates in criminal conduct may be held equally responsible as a principal actor. The law does not require the defendant to be the driver, only that he knowingly took part in the offenses alleged. At the conclusion of the evidence, the state will ask the court to find that the defendant's conduct meets the standard and to return a finding of guilt on the charged offenses. Thank you.
Objection.
Emma, go ahead and bring him up here.
Who was that?
That was the one that's been disrupting this entire time.
Up front, where?
Sir, this will be your one and your only warning. You disrupt my courtroom again, you will be in contempt of court. Is that understood?
I got one question.
What is your one question?
You was late to court and you called me up here to interrupt court just because I yelled objection.
Officer, please just remove this gentleman from my premises.
I hurt feelings, y'all. Hey, y'all be safe out there.
Bring him back up. Hold him in contempt. Throw a fine at him. He disrupted the court.
The gallery will please hold any comments to yourself. Do not disrupt this court. Defense, you have the floor.
Can everyone hear me all right?
You can be heard by the bench.
Okay, good. Just want to make sure. Your Honor, the defense would like to bring up again, same thing that happened in the pretrial stages here. The prosecution's information seems to be incorrect. Once again, they claim that only 2 people pled guilty, yet we were provided 3 counts of guilty pleas. Along with that, 3 people have pled guilty to driving the vehicles, which only 2 vehicles were found in the scenes, along with my client, Robert Holder, was not seen driving the vehicles in the vehicles up until the last moment in the body-worn camera that was provided when he was leaving the driver rear side of the vehicle, which he was shortly detained, I believe, by Ronald Kennedy afterwards, and then transported back to Vespucci. That is all from the defense.
Prosecution, you may call your first witness.
Your Honor, we're going to go ahead and call Lieutenant Matthew Holder to the stand.
They're married?
Or, hey, congrats, Matthew. Sorry.
I'll just sit right here.
Oh, come on around here. All over on this side, Matthew.
Oh, other side?
Yeah.
Different side.
Lieutenant Henry, do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right.
Prosecution, you're a witness.
Lieutenant, can you state your name, rank, and assignment for the record?
Matthew Henry, Lieutenant, badge number 10,
And how long have you been with the San Andreas State Police?
roughly 6 months.
And were you on duty March 9th, 2026?
Yes.
Did you respond to any calls for service that day?
Multiple.
And what were the nature of those calls?
A handful of them were ATM and store robberies, and there was approximately 1 or 2 911.
So, focusing on the ATM calls, what were the nature of those calls?
Could you repeat that, sir?
So, focusing on the ATM calls you received, what was the nature of those calls?
Nature of the calls were basically store robbery of an individual grabbing money out of it.
Where was the first location you responded to?
I believe it would be 594. It's right behind the main bank.
What did you observe upon arrival?
Upon arrival, I saw a black four-door vehicle on the right side where a individual in just his underpants, all white with a large back tattoo, multiple sleeve tattoos, and a black cowboy hat run out of the LTD into the back right of the vehicle.
Were you able to review any CCTV footage from that location?
No, due to the CCTV being messed up.
Did you observe any vehicles associated with the defendant?
Yes.
And can you describe that vehicle?
It's a black four-door. It's tinted with a, I believe like some sort of diamond shape on the back.
And did you encounter any similar vehicles to other calls at other locations?
Yes.
And Was that similar vehicle observed at those locations?
Yes, by multiple troopers.
What led you to believe that the same vehicle or group was involved?
The same vehicle was seen at multiple ATM and store robberies before and after this incident.
Whereas any ALPRs used during this investigation?
Yes, multiple.
Did you or any other officers initiate a pursuit of the vehicle?
Yes.
And were your emergency lights and sirens activated?
Yes.
Did the vehicle yield to law enforcement?
No.
And how would you describe the duration and nature of the pursuit?
Pursuit was very reckless, ramming into multiple locals at roughly, I want to say, 45 minutes to an hour.
And during this pursuit, did the suspect vehicle make any contact with law enforcement vehicles?
Yes, multiple vehicles.
And can you describe that? Can you describe those interactions?
Yes. First incident was up north in Polito, where the individual came out from an ATM robbery, where the black four-door vehicle came out, slammed into the side of my vehicle, and decided to back up and take off. The second incident would be down on the 13 and 15 split, where two of the same vehicles approached, and both vehicles were trying to actively pit me.
And based on your observations, how would you characterize those contacts?
Could you repeat that?
Based on your observations, how would you characterize those contacts?
I would say it was very clearly intended, as there was multiple room for them to drive around.
And how did this pursuit ultimately come to an end?
Not sure on the exact postal, but up north in the hills, a HSIU unit decided to attempt a pit maneuver and successfully pitted the vehicle into a tree.
And what occurred once the vehicle was stopped?
Multiple individuals, 3 males, 1 female, all jumped out of the vehicle and jumped different directions.
Did any of them remain at the scene and comply with law enforcement, or did they flee?
They all fled.
Were you able to observe the defendant, Robert Holder, at any point?
Yes.
And where was he located in the vehicle, if you know?
I believe he's somewhere in the back two of the vehicle.
And what did he do after exiting the vehicle?
Flee.
And did he comply with commands from law enforcement?
No.
Did the defendant flee from law enforcement?
Yes.
And how was the defendant ultimately identified?
Through MTT pictures and fingerprints that were found in the vehicle, and also fingerprint scanner on his own finger.
So a fingerprint scanner was used?
Yes, sir.
And that fingerprint scanner confirmed the identity of the defendant, Robert Holder?
Yes, sir.
During the pursuit, were lights and sirens clearly activated?
Yes, on multiple patrol vehicles.
And would the occupants of the vehicle be aware that they were being pursued by law enforcement?
Yes.
And did the pursuit occur over a sustained period of time?
Yes.
At any point, did the defendant attempt to surrender or separate himself from the vehicle prior to fleeing?
No.
And your observations are based on your own personal knowledge at the time?
Yes.
All right, I have nothing further, Your Honor.
Defense? Your
A
witness.
couple questions for also Lieutenant Henry. Mr. Henry, at which point did you originally see the vehicle in question?
It'd be at 594, the first LTD that I responded to.
And at any point did law enforcement lose contact with the vehicle or eyes on the vehicle at any time?
I disengaged the person.
And was that just you personally or all law enforcement?
I disengaged all law enforcement due to the erratic behavior of the driver.
And at that point, was my client shown to be in the vehicle?
Could you repeat that?
At any point prior to you disengaging the pursuit on the first instant, was my client proven to be in the vehicle or seen?
Your Honor, I'm going to object to the question. Defense has already made multiple comments saying that the defendant was within the vehicle.
Mr. Ado, could you speak up for the court?
Apologies, Your Honor. I'm going to object to the question because the defense has already admitted to that the defendant was in the vehicle, so this is an undisputed fact.
The objection is sustained. Defense will move on.
Your Honor, I know you said sustained and you would like to move on. There is two vehicles, neither which proves that my client was in which one it is. We're just trying to narrow that down here.
Your Honor, I'll say lack of foundation for the objection on that question.
The bench will rule this overruled. Reword your question, defense.
Okay, Lieutenant Henry, at which portion, which vehicle was it that my client was seen in?
It's hard to tell as both vehicles were very similar.
At which point were you able to positively ID that my client was involved?
Could you repeat?
At which point were you able to positively ID that my client was involved?
When we positively ID'd him was when he was put in cuff. He matched the description on previous body cam from up north when he was in the vehicle that decided to T-bone me, and also the individual that decided to flee from the very first LTD.
You're, just for clarification, you're saying that he matched the description of the white male with the large back tattoo?
Could you repeat that?
Just for clarification, you're saying he matched the ID of the white male with the large back tattoo leaving the first OTD?
Objection leading.
Sustained.
These chairs are slippery over here. Mr. Henry, at which point was, you said my client was placed into cuffs and seen on body worn camera during the pursuit?
Boy, he's having a hard time as the defense counsel.
At which point are you stating of when the body cam was?
Was that in the original sighting of the vehicle?
I'm not sure I understand your question.
You said in the original pursuit from the first LTD, you said it was a store robbery or ATM robbery?
It's a store robbery.
Store robbery, okay. In which you said before you called off the chase the first time, was my client positively ID'd in that vehicle?
When calling it off, no.
Next, when the vehicle was recited, can you walk us through what happened in the events that occurred there?
Recited as in after the first LTD store robbery?
After you called off the chase, I'm assuming that you found them again at some point and started a secondary chase?
Yes. After that, driving on to the 15th, another store robbery came out where pulling up to it, there was no one there, but noticed a black vehicle erratically driving past. I followed it down, and it matched the same description as the very first LTD.
Harry Weather out coming in with a rate of 1.
The same make and model.
Welcome,
Same
Raiders.
license
Scared the
plate,
crap
which I
out of
can
me.
get it for you. I don't know it off the top of my head. And the same roughly 3 individuals that were in the vehicle at the time.
So can you repeat that?
So the way that I possibly ID'd it was from the same make and model, the same license plate, which I'd have to get you the license plate for it, and then roughly the same 2 or 3 individuals that were in the vehicle.
And at any point during that chase, did you lose sight of the vehicle or call that chase off?
I eventually called the chase off again due to I was the only trooper and the erratic driving.
And then after that, about how much time passed before you found the vehicle again?
Oh, thank you.
This tertiary chase.
It always gets me because it always
I'd say
happens when it's so
approximately
quiet.
15 to 20 minutes when the Polito one came out.
And can you walk us through the events of that?
Activating lights and siren, heading up north into Polito. There was the ATM robbery. When pulling up, the same black four-door came out of the alleyway, T-boned me, and decided to take off, and that's when the third pursuit was initiated.
And again, on that one, can you describe how you matched that vehicle to the original?
Yes, same make and model.
Asked and answered. We've gone through at least 3 of these now.
Sustained.
Okay, during the events of that chase, can you describe what happened there?
During which chase?
The third one. The one
Yes.
involving Polito.
Yes, during the pursuit, when the vehicle decided to T-bone me, give me a tap on the right side of my vehicle, when he was exiting the alley, he decided to flee off again, heading south onto Great Ocean Highway, where he flipped around and went towards Polito again, passing through Polito, and heading under the, I believe, the Braddock Tunnel, or I'm not sure the exact tunnel that connects from Polito over to Grapeseed, but that tunnel where I believe it was 5025, Ronald Kennedy decided to place spikes where it spiked the vehicle and it was successful, and the vehicle just randomly disappeared.
And then at that point, once you've lost sight of the vehicle, when did you find it again?
The
Roughly how much
vehicle.
time has passed?
The vehicle was not found. It was still somewhere in the bushes, but it was not in the bushes. It's kind of hard to explain. It just kind of up and disappeared.
So after, can you explain what happened after you lost sight of the vehicle?
Yes, after losing sight of the vehicle, that's when I pulled up my LPR tablet and got both plates of both of the same matching vehicles and pulled them through ALPRs, where the last of the very first one for the ATM robbery that was completed, the tertiary chase, as we'll call it, was positively... Okay, sorry. Where the tertiary vehicle was possibly driving down the same path as we were, and it was spiked, it was still staying in the same area as that. Pulling up the second plate of the vehicle for the LPR, it pinged that it was over in, I believe, Joshua and 68.
And, excuse me, as far as you said you've matched both vehicles via plate and make and model, and that they were the exact same. At which point did a second vehicle come into this?
It'd be right before the 15 and 13 split before.
Which would have been in the first chase, second chase, or the third chase there?
It'd be in the second.
In the second chase, okay.
This is a very dry questioning session.
And then after the vehicles were found on the AOPR, what happened next?
After seeing the the vehicle matching the same plate that was entered into the second chase, we initiated a pursuit where we chased it for a little while and eventually lost eyes due to it. I believe Ronald Kennedy stated just some weird jank maneuvers, and he lost sight of it.
And then how much time had passed before you had another visual on the vehicle?
Objection, relevance.
Defense, your answer.
At no point up to this has my client been positively ID'd in the vehicle, just stating that there has been multiple times that the law enforcement did not see the vehicle. Just trying to get an answer on where it is in which of these chases, as it seems to have spanned over a larger amount of time than originally stated, along with not having seen him in the vehicle. He could have got in at any point, and along with along with these could be separate issues. He has not been positively ID'd inside a vehicle up to this point.
Your Honor, as I stated before, defense has indicated in the last pursuit in itself that his client was in the vehicle. Prior vehicles, prior pursuits, whether they're there or not under LPO4, the state is allowed to charge the person as the same regardless of, if they were in prior pursuits or not. It's the same as anyone else who's pled guilty.
Prosecution.
Which at this time, we're not stating probable cause on if he can and cannot charge him. It's just if he was or wasn't there is what we're trying to figure out.
Right, Your Honor, then I object on lack of foundation and again relevance as well, because the defense has no reason. The defense has basically acquiesced to the fact that he was in the last car that was stopped and then he ran. So anything prior to that really is. We can go down the road, but if Your Honor thinks that's a good use of judicial resources.
Prosecution has a point there, defense counsel. The objection is sustained. We're going to move forward, please.
No further questions.
Prosecution, cross.
I have nothing further for this witness, Your Honor.
The witness may step down. Prosecution, your next witness.
Your Honor, as pursuant to precedent by this court, recorded testimonies or affidavits written by officers are allowed to be introduced as evidence and is upheld by CR 1055. I am going to, at this point, introduce a deposition of the corporal on the witness statement, and I would suggest that we take it's about 10 or 15 minutes for both Your Honors and for the defense to review that deposition, as well as I did get confirmation, as Your Honor knows, from Ronald Kennedy via email that he's unable to attend today's hearing, but he was able to answer very similar questions I asked the lieutenant. So I'll also be introducing that into evidence. And again, I make a suggestion to this court that we take a recess while that evidence and information is reviewed by defense counsel and Your Honor. All right.
All right. This court will now be in recess. We'll take a 10-minute. We'll be back at 3 after.
All rise. Hang on.
All right, let's take a look. See.
Did you turn off your court mic?
What's that?
Did you turn off your court mic?
Yes, I did.
Oh, I forgot to before I left.
Oh. All right, let's take a look here.
My name is Bradley Ado. I'm the prosecutor on CR 1058. We talking to Jasmine Baker. Officer, can you state your name, rank, and assignment for the record?
My name is Jasmine Baker. I'm a corporal with the San Andreas State Troopers. My assignment is the arresting officer.
And how long have you been with the San Andreas State Police?
I've been with this SAST since December 26th of 2025.
And were you on duty on March 9th, 2026?
Yes, I was.
Did you respond to any calls of service that day?
Yes, I did.
And what were the nature of those calls?
They were multiple ATM robberies up in the Blaine County area.
This is what he just posted.
Yes.
Now, where was the first location you responded to?
The first location was at the LTD at 116 Grapeseed, Maine in Grapeseed.
And what did you observe upon arrival?
I observed no suspect vehicle or suspects.
Were you able to review any CCTV footage at that location?
Yes, I was, per the store management's approval.
And what did that footage depict?
Upon reviewing the footage, I witnessed a suspect that was half naked with nothing but white boxers and a white cowboy hat, along with shoes, walk up to the ATM, proceed to rob it, leave the store, and enter a black four-door sedan.
So you observed a vehicle associated with the suspect?
I did. Unfortunately, was not able to get a plate because the camera did not catch one.
Did you encounter similar incidents at any of the additional locations?
Oh, you can get a
Yes, I did.
And were the
What's that, Bo?
I said you get to have fun with that one.
Oh, yeah.
Because you know defense is going to ask that he'd be able to be cross-examined. Was he on the witness list?
Yes, but it was notified that he wasn't good. He wasn't. There was a chance he wasn't going to make it.
They could have reached out to him and crossed him. Got it.
Mm-hmm. All right, let's.
the same or similar vehicle observed at those locations?
Yes, they were.
And how did you or your fellow officers determine it was the same vehicle or group involved?
Per using the CCTV footage at said locations that gave us access to it.
Was ALPR used during this investigation?
During the investigation, yes.
Did you or your other officers initiate a pursuit of the vehicle?
The first pursuit was initiated by myself and Sergeant Emily Montoya.
And were emergency lights or sirens activated?
Yes, they were.
Did the vehicle yield to law enforcement?
It did not.
And how would you describe the duration and nature of that pursuit?
It was a short pursuit due to the fact that we lost eyes on the suspect vehicle.
And was there another pursuit initiated at a different time?
There was.
And were emergency lights and sirens activated during that pursuit?
Yes, they were.
And did the vehicle yield to law enforcement during that pursuit?
It did not.
And how would you describe that pursuit during the... how would you describe the duration and nature of that pursuit?
That pursuit was a longer pursuit, which ended up in the result of the suspect vehicle being stopped.
During that pursuit, did the suspect vehicle make any contact with law enforcement vehicles?
It did.
And can you describe those interactions?
Some of them, I believe, were accidental. Others, I believe, were intentional to prevent us from attempting to pit the suspect's vehicle to bring it to a stop.
And how did that pursuit ultimately come to an end?
Ultimately, the suspect's vehicle, whether through the officer's intervention or by accident due to the driver's error, it was successfully pitted to the side of the road where it came to a stop.
And what occurred once the vehicle was stopped?
4 suspects exited the vehicle and proceeded to flee from law enforcement officers.
Did any of them remain at the scene and comply?
None of them did.
Did they flee from law enforcement?
Yes, they did.
Were you able to observe the defendant, Robert Holder, at any point?
I myself did not. Sergeant Ronald Kennedy was the officer that pursued him.
Where is he located in the vehicle, if you know?
From what I was told by my fellow officers, he was a passenger of the vehicle.
And what did he do after exiting the vehicle?
He fled from law enforcement on foot.
Did he comply with the commands from law enforcement?
He did not.
Did the defendant flee from law enforcement?
He did.
How was the defendant ultimately identified?
Ultimately identified after being apprehended, and a rapid eye was used fingerprints.
All right, so a fingerprint scanner was used.
Yes.
And did that fingerprint scanner confirm the identity of Robert Holder?
Yes, it did.
During the pursuit, lights were clearly active, correct?
Yes, they were.
Would the occupants of the vehicle be aware that they were being pursued by law enforcement?
Yes, they would have been.
Did the pursuit occur over a sustained period of time?
Can you repeat that? You kind of...
Did the pursuit occur over a sustained period of time?
It did.
Is there anything else about this incident that you believe is important for the court to understand?
At this time, I do not.
Were your observations based on your personal knowledge at the time?
Yes.
At any point, did the defendant attempt to surrender or separate himself from the vehicle prior to fleeing?
No, he did not.
All right. That concludes the deposition for Corporal Jasmine Baker.
Okay. So that was her deposition.
Pardon me, is your honors?
Howdy, sir.
Howdy.
Taking a brief recess.
Yeah, we're.
Oh, yeah, we're just looking over some depositions.
Mm-hmm.
Understood. I don't mean to impose, but would either of you have like a beverage and a snack?
Hang on a second. I'll give you my last one of each, but I'm gonna run out front real quick and hopefully start my shit.
Was that what the?
All right. Let me. Eat and drink my. Top off my food and drink meter here. Mm-mm. All right, so Kennedy's was not a video. We saw Officer Jasmine Baker's deposition. Kennedy's was an email deposition. Answered the same questions. He answered the same questions that Hams and Officer Baker both got, and essentially his questions line up with that, or the answer to the questions line up with that of Officer Baker and Lieutenant Henry. They want both, and then now defense is asking that both of them be stricken from the record as defense was not made aware. Jasmine Baker would not be available to cross-examination, to be cross-examined, along with not having confirmation for Ronald Kennedy as well. Okay. So we got that. So yep, Kennedy was asked the same questions that Jazzy was and Lieutenant Ham was. They all of their answers line up with one another. So we're gonna go back out here and continue this.
All rise.
Courtroom may be seated. Okay, the court has reviewed the depositions of Officer Jasmine Baker and Officer Ronald Kennedy. Does prosecution have anything further they wish to add to the depositions that they submitted?
No, Your Honor.
Defense, is there anything that you would like to add for the court record in regards to the deposition?
The defense would like to move to have both depositions from Jasmine Baker and Ronald Kennedy stricken from the record, as they were not made aware that they would not be present today and did not have a chance to cross-examine them.
Your Honor, the state would object to any exclusion of the deposition affidavits. First off, Your Honor, the issue's already been addressed by this court and then reaffirmed in CR 1055 as existing precedent that sworn depositions and affidavits are admissible for the purpose of testimony, particularly when availability may be limited by witnesses or officers or anyone of that nature. This is not a new standard, and it's consistent with a long-standing practice of this court, where sworn testimonies are permitted as long as they're made under oath, subject to defense challenge. To that extent, Your Honor, the defense raises the concerns regarding, awareness and preparation. Those concerns don't affect admissibility. The proper inquiry before the court is whether the evidence is reliable and permissible, not whether the defense anticipated its use. Any such of those concerns go to the weight of the evidence, not admissibility. Accordingly, Your Honor, clear precedent is supporting the admission, and the state would request that the court allow the deposition and affidavit into evidence.
In keeping with the precedent that has been set forth by this court in previous rulings, in previous cases, both will be remain on the docket as evidence due to the facts that were presented in them, and as the prosecution elaborated on, the court has already ruled in the past that depositions are allowed to be entered onto the record as witness testimony and statements as affidavits, and thus the court will keep these two on as evidence. Prosecution, do you have any further witnesses?
I don't have any further witnesses, Your Honor.
Defense, any witnesses that you wish to call?
No, Your Honor.
All right. Prosecution, you may start your closing arguments.
Your Honor, the facts in this case are clear and largely undisputed. A vehicle engaged in a coordinated series of criminal acts across multiple locations. Law enforcement's attempts to stop that vehicle with license sirens activated, and it did not stop. Instead, it continued to flee. It rammed law enforcement vehicles. It continued evading until it was forcibly stopped. And when it did stop, the defendant was one of the individuals who ran. The defense has already acknowledged that the defendant was inside the vehicle. That fact is no longer in dispute. The only argument raised is he was not the driver. But that is not a legal standard. Under LPO4, a person knowingly participates in criminal conduct equally responsible as the principal actor. The defendant remained in that vehicle during multiple active pursuits, fully aware of what was happening, and made no effort to withdraw. Instead, he chose to continue. And when given an opportunity to comply, he fled. Did he attempt to surrender?
Judge Cooper, are you still with me?
Yeah, I'm still here. I think we might have had a little headache there. So you might just recess for a couple minutes.
All right, I'll call this court into recess while the attorneys and the defendants and anyone else
Address their headaches.
address their headaches. Yes, address their temporary medical situations. All right, we're recessed until they return.
Now rise.
All right. So we are recessed until they return. I need to look at something here. $25, $7.99. $808. All right, let me look at a couple things here because I think the grand theft charge that they didn't have PC before actually ended up getting PC based off the evidence that was presented. I just need to look in here at something. We got the arrest reports for the other 3 individuals that were in the car that were filed as evidence. I need to see if there was ever any mention of how much was okay, they pled guilty to it. They pled guilty to the grand theft. $7.99. Port 300. Okay, so PC was granted on the grand theft. And that's I found what I was missing in that in the arrest report from Mr. Holder was the estimated value. I needed the numbers because 2-8 grand theft has a number associated with it, a specific dollar amount that has to be met in order for it to be found. Give me just a second. All right. Little staff was being grumpy. Had to address him real quick. All right, let's see here. Guilty.
I believe we're just waiting on Mr. Ado. I'll let you know when everybody's back.
Thank you.
All right, Miss Emma. I believe Mr. Ado is back now.
Wonderful.
Alrighty.
All right. So, yep, there was a number associated with it. So, because of that, we're going to now have PC with the evidence that's been presented. There's going to be PC that's found during the trial phase for the charges. So,
All right.
all right, the courtroom may be seated. Mr. Ado, you may proceed with your closing. If you wish, you can restart, please.
Thank you, Your Honor. Your Honor, the facts of this case are clear and undisputed. A vehicle engaged in a coordinated series of criminal acts across multiple locations in the state. Law enforcement's attempts to stop the vehicle with light sirens activated. The vehicle did not stop. Instead, the vehicle continued to flee, ran law enforcement vehicles, and continued evading until it was forcibly stopped. And when it stopped, the defendant ran. The defense has already acknowledged that the defendant was inside that vehicle. That fact is no longer in dispute. The only argument raised is that the defendant was not the driver, but that is not the legal standard. Under LPO4, a person knowingly participates in criminal conduct is equally responsible as the principal actor. The defendant remained in that vehicle during multiple active pursuits, fully aware of what was happening, and made no effort to withdraw. Instead, he chose to continue, and when given an opportunity to comply, he fled. At no point did he attempt to surrender. At no point did he attempt to separate himself from the conduct. That is not passive presence, that's participation. Your Honor, the evidence, including the officer's testimony, fingerprint identification, and the defendant's own actions, establish that he knowingly took part in criminal activity. You don't stay in a fleeing vehicle, run from police, and call yourself uninvolved. For those reasons, the state respectfully asks this court to find the defendant guilty of the charges supported by the evidence. Thank you.
Defense, your closing arguments.
Gunnar, can you hear me okay?
Yes.
Oh, okay, it's doing the same thing. Gunnar, my client was not seen up until the last portion of the chases, where, thanks to Lieutenant Henry's testimony, was shown that they did not see the vehicle. The previous chases, during which where the vehicle was stricken, was prior to the last time this vehicle was seen. My client was not positively ID'd until he was seen fleeing from the vehicle, which, mind you, was a vehicle, as we saw on the body-worn camera, was struck going at a high rate of speed and thrown into a tree. He moved away, and in the body-worn camera you can see he was detained by I believe it was Ronald Kennedy, where he was promptly taken back to the station. At no point did he resist Ronald with his being arrested, along with not being seen in the vehicle prior at any of the times the vehicles were allegedly attacking, or sorry, attempting to pit out any of the officers involved vehicles. My client would continue to say not guilty on the charges of aggravated assault ×2, along with
What's up, Vance?
felony evading.
Though I'm not Blue tonight, I'm Blue's
along
daughter,
with,
Emma.
Resisting a peace officer, Your Honor. And that is all from the defense.
Doing good, Vance. How are you? All right. The court has heard the arguments from both the prosecution and the defense. At this time, we're going to call the court into recess while all of the facts of this case are reviewed. We will come back into session at the 9:40 Central Time. Yeah, they do. Well, I mean, it is her daughter, so.
Now, you got a fun one on your hands here, don't you?
Oh, yeah. So, my question to you.
Yes, ma'am.
You approved the warrant for the other subjects.
I did.
And they gave a rough estimate of the value of the ATM, but nothing was ever recovered.
This is correct.
With the rough value estimate and the fact that nothing was ever recovered, would you find grounds for grand theft still?
So the issue that I have, all right, we cannot say for certain how much was taken.
Exactly.
It could have been $500 each one. We can't speculate that. Now, the other issue is the cost of the ATM itself and the repairs to the ATM because they were broken into. There's a lot of things that come into play on that.
Yeah. Unfortunately, I don't have any evidence to suggest give me any money value, and there's no other evidence besides the 911 reports of ATM robberies.
Right, but between the 24/7s, I thought there was a total given on those.
I looked through all the arrest reports and only saw the estimated values.
Let me take a look. I thought the 24/7s had totals.
Yeah, and I was looking at the looking at the supplemental report that was used for the arrest warrants.
Okay.
It shows, under 2.8, it shows individuals matching above descriptions were seen on scene leaving scenes or identified on CCTV/body-worn camera footage during several ATM robberies. Due to current limitations with state resources, the exact dollar amount stolen from each ATM cannot be determined. However, it is commonly known that ATMs typically contain an amount approximately 500 to 1,500 each. With approximately 20 ATMs targeted, the estimated total stolen amount will exceed 10,000, meeting the threshold for grand theft.
Right. And that's the challenge, because we don't have
an exact dollar amount, or there's not even evidence of any money being recovered when these subjects were arrested. So,
right, but it's also because of
limitations.
So that's a good question. And I think that's what I based it off of, was because of limitations that we have right now.
If they would have found money from these ATMs on these people, then yes, that would make that 2.8 a whole lot easier. But because there was no money recovered during any of the arrests, then I'm not going to move forward with grand theft.
Okay.
I had no evidence submitted for aggravated assault, just witness testimony saying that it happened.
None of the body cam footage, none of the dash cam footage showed them slamming into the vehicles? Because that's what the aggravated assault was for.
Yeah, let me double check Henry's.
I mean, let's be real. Innocent people don't flee.
I said there too. You're gonna have a 10
Yeah.
with a black four-door vehicle.
That's gonna be the same black quarter vehicle we've been chasing for a while. I wanted to terminate it, but
I'm gonna try to get this. There we go.
I said there too. You're gonna have a 1080 with be holding something outside the window. To the exit, they're gonna not be taking the exit, gonna still be continuing. Be a little behind. If possible, can we get some spikes set on the 13? They'll be taking the. It's gonna be identical. They're gonna be sandwiching the.
Oh my goodness. It's... Give me issues.
We're gonna be taking the exit at 1050, still continue turning back around, heading towards Grapeseed. Ronald, you set for spikes? Be passing the U-toll going south. There's gonna be 2 of them at this time. I'm gonna take the first one.
Avoid headaches, nausea. Hell hydrate.
They're gonna be sandwiching me at the moment.
Hell hydrate, Boba. Let's see here.
Maybe taking the 15 now. Fucking Toad. I have him again here. Beheading on the GOH. It's Polito at the moment. We're gonna be heading up to the 13, about to pass the gas station at 070.
Alright, so I just did a little bit of research.
Mm-hmm.
Gotta be entering the tunnel. We're gonna be entering the tunnel now. Go ahead.
By the way.
Halfway through the tunnel.
Spikes out, spikes out, spikes out.
Emma?
Yeah.
Oh, sorry. I didn't know if you heard me. So you can.
Time's occupied.
Yes,
passing Yellowjack.
Or aggregation.
5 extra Union 3.
If the theft's a part of a single scheme plan,
slamming on its brake, it just slammed into a guardrail.
Which everything is kind of pointing that direction. This was
I'm
one
break off
night,
pursuit
it
since you're on MSHSIU.
one after another, things like that.
I mean, Ronald, do you want to come take my spot? I'm gonna go ahead and get my SDX. Do you have full fuel?
If
Sure.
they gave an estimation, which they did,
519.
and the officers, the witnesses, and the records supports those estimations. A reasonable fact finder can conclude that the total exceeds $10,000. The grand theft can be sustained. If the estimates are shaky, no foundation for the numbers, it's pure guesswork, ATMs usually have that money, or there's no testimony tying the value of these specific ATMs, right?
Mm-hmm.
Then you can't prove it beyond reasonable doubt. But you can lessen the charge to a theft charge if the facts support the theft charge. So rather than grand theft, you can drop it down to a theft charge. So that is totally up to you.
I don't think I'm looking at everything. I don't think I'm comfortable with what I do have to move forward with anything on the theft, and I already didn't have PC for it to begin from the PC hearing, and nothing that's been presented thus far has proven beyond a reasonable doubt that they stole anything.
But LPO4 attempted or being successful, the charge is the same.
Yeah.
The other thing.
All right. So yeah, well, with LPO4 and the fact that it was 20 different occurrences, and it was the same vehicle to each occurrence. All other parties in the matter have been charged with have pled guilty to grand theft.
With the exception of one, there is one still outstanding that is fighting his case.
Which is Mr. Holder.
No.
No, there's another one that's
Kane.
fighting. Oh, Kane is fighting his?
Yeah.
Okay. Anyway.
I sent you something if you decide to do a theft charge rather than grand theft, if you do.
And seeing that he was in the vehicle that was recklessly driving to escape, I can still hold him on 820. In accordance with criminal accomplice LP4. He has 410 because he fled on foot and failed to comply with lawful orders. The aggravated assault, the body cam footage, I don't have anything about Ram. I didn't see anything to facilitate that outside of the witness testimony.
But remember that testimony is as good as body cam footage.
Mm-hmm.
Especially when you've got three different stories all adding up to be the same. Because you said all the questions were the same. They included the question, that they, well, I don't remember, yeah, I know Henry said they rammed him a couple times. I know Kennedy said that they did. Did the last one? No, what was her name?
Jasmine Baker.
Jasmine, that one. Did she say that they rammed a couple of times? And I'm sorry, it was LPO1 is attempted versus, anybody that attempts also, falls under the same category unless they're specific for AKA attempted murder.
I don't see anything in Kennedy stating that they during the pursuit, did the suspect vehicle make contact with any law enforcement vehicle? The pursuit was reckless, and I believe there were times the vehicle went into oncoming lanes. Didn't answer the question. Just said it was reckless and that they went oncoming.
He did say one of the vehicles was spiked by me near the Sonora Tunnel. The vehicle was dumped. They got out into the shafter that was wrecked out by an unintentionally contact from my unit.
Yep, he made contact with him, and that's in the body camera footage.
Unsure if the striking patrol cars was intentional. So he's not sure if they. That's where I saw it.
Oh, yeah, yeah.
Not sure if they were intentional.
Intentional hits. Yeah, the one contact that I did see in the body cam footage, it looked like it wasn't intentional because they made contact with the front of Lieutenant Henry, but then the world rewound that instance for a moment, and they pulled out normally like nothing happened. So I don't know if it was intentional or not. So,
Gotcha.
and that's the only instance I saw in the body cam footage. Yep. All right, so I got 2 people that pled guilty to the grand theft. I got 2 that are fighting. I got felony evading, resisting,
And I believe there's still one outstanding on the
and
warrant.
and 1 out. Okay, and then the 2 aggravated. Okay.
Just so you're aware, don't know if you are aware, but both parties have returned.
Okay, welcome in.
Yes, sorry.
You missed it. I threw somebody out of my courtroom.
Oh.
That's okay. I almost
was
held
there
him
any
in
of us
contempt
here?
even before.
Nope.
Oh.
Henry escorted him out of my
actually
courtroom.
It's okay.
Okay. Well.
And then Henry had him escorted out of my courtroom.
Oh, well, I've been very busy today.
Understandable. Okay, so not guilty, 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 and then grand theft. Yeah, I don't know. I'm still up in the air on grand theft.
Do you believe they went out to steal from ATMs?
From looking at the evidence provided to me and reading through all the incident reports, the fact that there was 20 ATMs hit in one night, yes.
Okay.
If it was like 1 or 2, that would be understandable. Like, you know, maybe they just went in there, messed with it, and set the alarm off. But 20 ATMs is a little much.
So the question is in those 20 ATMs, was there $10,000? Both between how much damage they caused and how much they took or could have taken. Okay. If we knew how much money came out of an ATM whenever they do that, it'd be easier, 100%.
Mm-hmm.
But we don't have that. If we knew how much an ATM costs, 100%. But we don't have that.
All we have is estimations, and what was reported that there were 20 calls for service for ATM robberies.
And wasn't there 2 LTDs or 2 convenience stores?
Yeah. Yeah, something along those lines.
Okay. Why they couldn't get numbers out of them is beyond me, but that's okay. I mean, ultimately, you know, do you believe there's enough to say that it was over $10,000? If you don't, then you go with the theft charge. If you do, then you go to grand theft charge.
Oh, the issue is I don't have just a plain theft charge. We have petty theft or grand theft, and they both require a monetary value.
Petty theft would be
$5,000.
Anything less than 5.
Anything less than $5,000.
Right.
Again, though, the arguments there is, what's the monetary value? Which the monetary value is a requirement for our 2 theft charges. The fact that there was reports of 20, but there was no money recovered, only speculations. If they would have recovered cash, then yes, but nothing was ever recovered.
No, it's steal property worth $10,000 or less, or fail to pay a contractor invoice under $5,000 within a set time frame.
Was that for petty?
Yes. So it's steal property worth less. And the second part of this doesn't matter, right? Because it's an invoice and it's not an invoice, right? So it's just steal property worth $10,000 or less, or attempt to steal property worth $10,000 or less under LPO 1. So that could be $1, and they could be hit with petty theft.
And how did they come about the value? The estimated value, 500 to 1,500.
I believe that is based off of what we know in state for how much they get out of those whenever
The ATM carries.
Right. Now we can ask for clarification on it, but you would have to delay your ruling. Based off of what you have today, that's what you got to go off of.
Yeah. So based off of what I have, I'm looking at. I have guilty on resisting a peace officer, guilty on felony evading, not guilty on aggravated assault because there's conflicting information. But I have two pleas of guilty for I have two that have already pled guilty to grand theft. And then two that are fighting the case.
Yep.
And yeah, so I think based off of the fact that there's two from this group that have been captured and have pled guilty to grand theft, his co-conspirators are admitting that they stole over 10,000. So based off the evidence that was presented in the court, PC's been found for 208, and the court will find guilt.
I think you're right about the Raymond though, like the aggravated.
Yeah, there's conflicting information. Because one officer's saying it, I don't think Officer Baker was asked that question or answered. And then Kennedy said he was unsure if it was intentional or not.
Can you, and how long have you been with the same?
Of 2025. They were multiple ATM robberies up in the Blaine County area. The first location was, I observed no suspect or management's approval.
And what did that footage?
In a white cowboy hat.
Did you encounter similar incidents at any of the additional locations?
Yes, I did.
It was determined it was the same vehicle or group involved.
For using the CCTV footage at said locations that gave us access to it.
Initiate a pursuit of the vehicle?
The first pursuit was initiated by myself and Sergeant Emily Montoya.
And were emergency lights or sirens activated?
Yes, they were.
Did the vehicle yield to law enforcement?
It did not.
And how would you describe the duration and nature of that pursuit?
It was a short pursuit due to the fact that we lost eyes on the suspect vehicle.
And was there another pursuit initiated at a different time?
There was.
And were emergency lights and sirens activated during that pursuit?
Yes, they were.
And did the vehicle yield to law enforcement during that pursuit?
It did not.
And how would you describe that pursuit during the... how would you describe the duration and nature
Let
of that
them know
pursuit?
we're just going to be a couple more minutes
That
here.
pursuit was a longer pursuit.
Okay, I'll just go with a check.
Which ended up in the result of the suspect vehicle being stopped.
4 minutes in, by the way.
During that pursuit, did the suspect vehicle make any contact with law enforcement vehicles?
It did.
And can you describe those interactions?
Some of them, I believe, were accidental. Others, I believe, were intentional. To prevent us from attempting to...
Some of them were accidental.
Some were intentional. Then Lieutenant Hand's testimony in the stand said that they were intentional. He believes they were intentional, and then Kennedy says that he believes they were unintentional. So
yeah, you're kind of 50-50.
I'm 50-50. I have contradictions across the board on that one.
Yeah.
So
I
yeah.
think you'd be justified in dropping them.
Yep, I'll drop the I'm gonna drop the aggravated then.
I mean, he said he wasn't. I guess that's the other thing. He didn't know if they were intentional or not. That's the only thing with Kennedy's. He's like, I don't know if they were intentional or not, right?
Yeah, he said he doesn't know if they were intentional or not. Jasmine says that she believes some were intentional, some were not intentional. But then Lieutenant Ham said on the stand that they were. He believed that they were. There were multiple instances. He believed they were actually trying to pit him. So I have 3 different answers to one question.
Right.
So because of that, I have conflicting witness statements on that. So I don't have enough to substantiate it.
I would agree.
So
I'm gonna go sit down. You take your minute.
Yep.
Yeah.
All right.
She's actually just going to be a minute longer, ladies and gentlemen. So be patient.
Okay. Court may be seated. Will the defense and defendant please stand? Mr. Holder, after review of the facts of this case that were presented in the court today and the facts that have been discovered onto this docket, the court finds the following ruling. For the charge of 109A, aggravated assault against a government employee ×2, this court finds the defendant not guilty. For the charge of 410, resisting a peace officer, this court finds the defendant guilty. For the charge of 820, felony evading a peace officer, this court finds the defendant guilty. For 208, grand theft, this court finds PC for that charge and thereby finds the defendant guilty. The court rules that no further sentencing or fines shall be issued to the defendants. Within the next 24 hours, DOJ will be issued. This court is hereby adjourned. Phew.
Yes, ma'am. Hello. Howdy, howdy.
I wanted to ask, did you have a name for who you had to remove from the... Just out of curiosity.
Oh, well, he was on Birdie. See if his name was on there. He was Deasy Street.
Your Honor, Ms. Bliss.
Yes.
The defense attorney would like to speak to you.
Okay. He can
Would you like
come.
me to bring him in?
Bring him and prosecution.
Yes, ma'am.
Oh, I just had one quick question.
Yeah, give me just one moment. Let's get prosecution in here so we don't have ex parte.
Oh, yeah. No problem.
Okay, prosecution is here. What is your question?
Will, since my defendant already paid his fines and served his time, would he be reimbursed for the fines that he paid in relation to
the not guilty?
Yes.
Yes.
Okay, just wanted to.
Yeah,
make sure.
that'll be coming in the next 24 hours once I put together the DOJ. I'll adjust those charges, and any fine for charges that were found not guilty on will be returned to your client. Let him know that he might get an email saying that he's been served a subpoena. Do not worry about that. That is how our system works in returning fines.
That's no problem. We just wanted to double check on that. All right, that was it.
All right, thank you.
Appreciate it. Thank you.
Oh, that was easy.
Yeah, sure, why not?
All right, so.
Oh wait, I got the other one.
Yeah, you got the other one. Have fun.
Mine's a little bit different though. Why this wasn't introduced to you is beyond me, but there is also a confidential informant on this case.
Oh, really?
Yes.
Well, I guess I guess it didn't really matter for this one because he was caught on scene.
Yeah.
Versus, I think the CI comes into play onto yours because the CI was used to.
But the CI also confirmed that your person was privy to all this information, which would have helped establish that he knew about what was going to happen that night.
Oh, well.
Which is why I kept my mouth shut.
Yeah, I knew.
Until now. It's over.
I knew that there's some special circumstances on yours. I didn't realize that he was one of the subjects for this and it tied into this, but nonetheless, it's already been handled.
So, yeah. That's why I was like, I mean, I was trying, I had to do my damnedest not to say anything, that's for sure. Because I'm like, I don't want her being swayed by something that I know.
That you knew that I didn't, yep.
Right.
But nonetheless, I think I'll get this DOJ together. I'll get that fine returned, and then we'll go from there. Alrighty, let me get the paperwork started. Yay, paperwork.
You have fun with that.
Alright, gang.
Well, you're not trying to get beat up by this feller that wasn't too happy.
Okay. Well, thanks for hanging out with us. State versus Holder has come to an end. We'll see if they appeal the ruling. I saw you, DJ. I'll get you taken care of here. And oh, flashbang. Hope no one was asleep. So I'm gonna get some the DOJ or the declaration of judgment taken care of. Get the fines for the not guilty charges returned. And we'll be down the road for till next time. Keep putting in the hard work because one day it'll pay off and we'll be back one day. Take care, everyone, and happy Easter.